यहाँ स्टार्ट हो जाएगा।
ला दो हम आपको अरे बीच में
Today is a day of great pride and dignity for our college. Today, Senior IPS Officer Honorable Mr. Arun Chaudhary will deliver lecture to the students of SKJ Law College on the criminal justice system. Now, we cordially invite Mr. Jayant Kumar, the director of this college, for the opening and welcome address of this lecture session.
Honorable Mr. S.K. Mishra, President of the College, our Secretary, Dr. Mrs. Ujjwala Mishra, our distinguished guest speaker, Mr. Arun Chaudhary, IPS, Mr. K.K. Tiwari, Principal, Mr. B.M. Azad, Vice Principal, dear teachers, staff, students, and dear press and media persons. Dear distinguished guest speaker and participants, it is a great pleasure for me to welcome you here on the occasion of lecture to be delivered by our distinguished speaker, Mr. Arun Chaudhary, IPS, topic criminal justice. We all know that he was an IPS officer in Bihar cadre who served as ASP in Bhojpur and senior SP Patna. He also served in state intelligence, CID, and staff officer to the DGP Bihar. Later on, he served in Intelligence Bureau, Government of India in sensitive areas of Jammu and Kashmir and also served as head of Immigration Services of India. His last assignment was as DGP of SSB in charge of border security and Indo-Nepal and Indo-Bhutan borders. We are very fortunate to have his valuable lecture on criminal justice system, and particularly the students of law will be benefited as this topic will throw light on the subjects like IPC, CRPC, Evidence Act, administration of justice, and legal and constitutional history of India. The criminal justice system in India was based and established by the Britishers during the British Raj. The implementation of the criminal justice system rests on three institutions, that is the police, the courts, and the prisons. The system more or less remains the same without any major changes. In sum, we can say that it has four subsystems, these being the legislature, parliament, enforcement, police, adjudication, courts, and corrections, prisons, community facilities. The procedure of administration of criminal justice in our country is divided into three stages, namely investigation, inquiry, and trial. The purpose of criminal justice system is to deliver justice for all by convicting, punishing the guilty and helping them to stop offending while protecting the innocent. Different committees have suggested from time to time to make the criminal laws more transparent and to check corruption in police system, judicial system, and prisons. I am sure our distinguished speaker will discuss in details which will be benefited for all of us. I again welcome our distinguished speaker and all the participants on this very occasion. Thanks.
Moving on, we cordially invite our chief guest speaker of this lecture session, Senior IPS Officer of Bihar Cadre, Honorable Mr. Arun Chaudhary.
Thank you very much. Director Sahab, I think I am visible to the students who are.
Yes, sir. Yes, sir.
Okay. Okay. So.
वो म्यूट कर दिया गया उन लोगों का.
हाँ नहीं ठीक है ठीक है.
जी.
So the director, Mr. Jayant Kumar, and Professor B.M. Azad of the SK Law College, it is a privilege for me to. I have talked to many senior police officers who are taking training, also administrative officers who are taking training, whether that was in Mussoorie or here. But I have never talked to a group of students who are in law college. Your director has already given an executive summary of what exactly is the criminal justice system in our country or in any other country. किसी भी देश, चाहे हमारे देश में जो हमारा क्रिमिनल जस्टिस सिस्टम है, वो लोग कहते हैं कि एक चैरियट की तरह है, एक रथ की तरह है, और वो रथ के जो चार घोड़े हैं वो पुलिस है, बार है, जुडिशरी है और करेक्शनल इंस्टीट्यूशंस है, जिसके बारे में आपके डायरेक्टर ने आपको बताया. सबसे इम्पोर्टेंट विंग, और आई वुड नॉट से कि सबसे इम्पोर्टेंट विंग, एक विंग जो है वो पुलिस का है और मैं 38 साल पुलिस में सेवा कर चुका हूं और उसके बाद 2014 में सेवानिवृत्त हुआ. I retired in 2014 and I have continuously from that time been associated with a think tank with things about international relations, conflict areas where laws and law can be administered. But as far as the criminal justice system of any country is concerned, it is practically same and basically, as your director has told you, based on the British jurisprudence or judicial system. Even in America, the criminal justice system has all these four wings, so to say, which takes the criminal justice system from one place to another. The first wing is the first wing is the police. And the police in India has come and been associated by the Police Act of 1861. It is called Act 5 of 1861, the Police Act. Now this Police Act, if you see the timing, it is in 1861, just after the administration of Indian colonies went from the East India Company to the British Crown. Now, the British Crown came up with this Police Act because it had seen the miscoordination of the East India Company, say in Kanpur, Meerut, and Delhi, and in Calcutta, when the 1857 First War of Independence started. They had to suffer a lot. A lot of people of the Britishers were killed, and that is why they decided to take things in their own command. And so India came under the British Crown, and from Governor General, we had Viceroy here. The Police Act of 1861 does the similar thing of saying what a police is and what a police should be doing. The most important sections of these Act is Section 3. Section 3 of this Act, where the superintendence and control of the police as an organization was given to the state government. But in a district, it was vested in the district magistrate. So the reference of any magistrate in the Police Act means the district magistrate of that district. The police in any state, जिसे हम इकाई मानेंगे, स्टेट को इकाई मानेंगे, उसमें पुलिस सिर्फ एक ही होगी. वो पुलिस जो दो काम करेगी. एक, one is basically control and maintenance of law and order, which is called public order. And the second is investigation and detection of crime. The police, as it was formed under the Section 8 of the Police Act, all the police officers, right from the district superintendent of police, which has got a mention in the Police Act, till all the subordinate officers, they take their certificate of working as a police officer from Section 8 of the Police Act. This Police Act empowers them to maintain police order, to maintain public order, and go in for detection and investigation of crime. Now, what is crime? The first thing is, it is an offense. Crime is an offense as it is in some statute book, as it has been given in a statute book what crime is. Say, for example, murder, kidnapping, theft, dacoity. These are things which are said to be crime. And this has been codified in the Indian Penal Code. I will come to that later, but going through this, the Police Act tells us and gives us the power to investigate a crime and go for public order. Some of the most important sections of the Police Act are (13), 14, 15, 15A and 16 sections of the Police Act. Now, these are police acts. These are sections where the police officer can be appointed. There can be a quartering of additional police force when there is a massive law and order problem, which is still valid today also. It is awarding compensation to sufferers for misconduct of inhabitants of persons interested in land and other things. That means you must have heard very recently, आप लोगों ने सुना होगा recently कि जो दंगा फसाद यूपी में हुआ, वहां की स्टेट गवर्नमेंट ने ये निर्णय ली कि जिस क्षेत्र में ये दंगा फसाद और उपद्रव हुआ है, वहां के लोगों पर हम कुछ सख्ती से उन पर कॉम्पनसेशन के लिए एक्ट करें. तो ये इसी पुलिस एक्ट से और अन्य एक्ट से भी एम्पावर्ड होता है स्टेट गवर्नमेंट कि किसी भी क्षेत्र में, किसी भी क्षेत्र में अगर दंगा फसाद होता है और स्टेट गवर्नमेंट ये फील करती है कि हम उसके लिए वहां के लोगों को ठहराएं, बिकॉज उनका भी दायित्व होता है. It is their also responsibility to quell any mass law and order problem. These things have a bearing on what had happened in 1857 to the Britishers. A lot of people lost their lives, and that is why they wanted that from the civil policing, from civil administration, the army should be taken off and the police should be brought in. And whatever remained at that time of the police forces of different principalities, उस समय जो राजा रजवाड़ों का पुलिस फोर्स था, उसको एकजुट करके एक पुलिस फोर्स का सृजन किया गया. They were made into a composite police force and given to one state and different states. In that state, there was an Inspector General of Police who was the head of the state of the police forces. There was the Superintendent of Police who used to be the Superintendent of Police in a district. आज के दिन में भी जो एसपी जिनको कहा जाता है, वो इसी पुलिस एक्ट के तहत काम करते हैं. और आज भी ये पुलिस एक्ट वैलिड है, और जो सुपरिंटेंडेंस एंड कंट्रोल है, जो सेक्शन 3 में बात होती है, वो बात डिस्ट्रिक्ट मैजिस्ट्रेट के पास है. आज भी डिस्ट्रिक्ट मैजिस्ट्रेट जो भी पुलिस का एक्शन होता है उसके लिए वो रिस्पॉन्सिबल हैं और वो कंट्रोल करते हैं. तो पुलिस एक्ट जो के तहत हमारा पुलिस है, और पुलिस क्या करती है? What does the police do? The police, as I have already said, has been entitled or given the responsibility for the investigation of case, number one, and for public order. And for that, we have different police codes. We have different police codes like the IPC, which is the penal code. Then we have the Evidence Act, which tells us how evidence for investigation or any other matter which is brought to the court should be mustered. And 3 is basically, we are talking in terms of the CRPC, the Criminal Procedure Code. As you are students of law, there is a criminal, I will be just talking about the criminal procedures and the criminal justice system. There is a civil side also. So the Criminal Procedure Code gives us an idea of how the police should act in times of public order, in times of investigation of cases, and how the police files a charge sheet in the court, and from then on, the court proceeds on. So the next thing is basically the police, how it functions. In the Police Act, the jurisdictional things are one state and the other is district. So the state is divided into districts, and the districts have station house officers, like the police stations. The police stations in any area has a geographical area. It is already described a geographical area, and any crime committed in that geographical area has to be brought to this police station, which has to take cognizance of any act of offense. Now, offense, as you know, you are all senior students of law, you must be knowing the differentiation between a cognizable offense and a non-cognizable offense. Now, the cognizable offense is the one in which we draw an FIR, the first information report. Although it is called the first information report, but over a period of time, we have seen that even some delay which is explained, it can be turned into a first information report. Now, anybody coming to the police station or any act of offense which has been created in a jurisdiction of a police station, which comes to the knowledge of the police, and it goes there to find out what has actually happened, then in oral or in written, a FIR can be registered. When I say oral, there are people in most of our country is in the rural area. 80% to 90% of our country is in the rural area. So most of the people who come to the police, maybe they are illiterate. So it is the responsibility of the police to go to them, try to find out what exactly has happened to them or their family member or to their property, and translate that or convert it into a written FIR, complaint. The complainant of this could be the police officer himself or the person to whom this crime has been committed. Now, a lot of things have been talked about the registering of the FIR. Why the police does not register an FIR which is brought to the notice of the police. A lot of things have happened, and in most of the time, we have tried in most of the police states to simplify the FIR. And now, in the day of technology, even an email to the police station has to be converted into a FIR. So once the FIR is registered in a police station, that means it is a cognizable offense. Suppose it is a non-cognizable offense, what happens? What does the police do? The police, in a non-cognizable offense, tries to register his complaint in what is called a Roznamcha, or in our state, it is a station diary in a police station. In that, the complaint has to be written, and if it is a non-cognizable offense, it is on the police officer to explain to the complainant that, look here, this is a non-cognizable offense. The police is not supposed to act in this and has to convince the complainant. As far as the investigation is concerned of cognizable offense, after registering an FIR, the police officer starts investigating that case and tries to muster evidence according to the Evidence Act in the particular crime which has been committed or the offense which has been committed. For example, in the Indian Penal Code, the Penal Code is around 511 sections of the Penal Code. But the most major, and there are 23 chapters, if I remember correct. But the basic chapters are, one is the crime against body and the crime against property. As you find, even in the Police Act, right in the Police Act, it has been written that it is embodied in the to the. हम थोड़ी देर में बात करते हैं तुमसे. So in the police, it is embodied that the police is meant to safeguard the body, the person, and the property of the person. So any state is basically एक स्टेट का ये रिस्पॉन्सिबिलिटी है. दिस इज द responsibility of the state to provide protection and security to not only the body of the person but his property also, and that is how the Indian Penal Code has also been divided. Although the Indian Penal Code, if you see how the Indian Penal Code came into being, the Indian Penal Code had started functioning as a commission under Lord Macaulay in 1835 under the British Crown. At that point of time, there was no Gadar, there was no First War of Independence. But the plans of the British Crown was in place to come and take over the administration. And that is why it was trying to get an Indian Penal Code incorporating the laws of this land also, but basically it was the British law which was being pushed into the Indian Penal Code. So the Indian Penal Code has got sections for actions against body like murder, kidnapping, rape, hurt, simple hurt, minor injuries, grievous injuries. Now these are in one section where you have an offense which is being described and the punishment follows these sections which describes the offense. Now, this part of the criminal justice system is with the police. The police has the hierarchy, as I told you, the Inspector General of Police, now the Director General of Police in the states. Then you have the DIGs, IGs. But in the Police Act, it is the SP who has been mentioned. So the SP of the district is a very important person. And after that, the officer in charge of a police station is the most important part of it. Because he is the person who investigates the case. He is the person who is the first responder to any offense or any public disturbances. And he is the one who informs everybody, he reacts to what is happening in the police station area, and he informs his higher formations for if he needs force or otherwise. The second part, or the second, as I told you, it is a chariot. So the first horse is the police. The second horse is the is the bar. Basically, all the students of the law college would, after graduating from the law college, would be registering in the bar and will be start practicing in the local courts of the district courts and some in the high courts. Now, this is the part, is the second horse of the criminal justice system. Now, this is what is called the prosecutors. Now, the prosecutors in a criminal side is the prosecutor from the state. The difference between the civil and the criminal law, as you all know, is in the criminal side, the state is one party and the accused persons who after the investigation are charge sheeted are another party. So for the state, there are prosecutors. So there are prosecutors right in the junior courts, which we call the judicial courts of third, second, and first degree. And then you have the district courts, which is the district sessions and additional district judges courts. In that, we have public prosecutors. Earlier, we had the system of police prosecutors. Hello. Hello. Am I laudable?
Yes, sir. Yes, sir.
Yes, sir.
So I was talking about the police prosecutors and the second horse of the chariot of the criminal justice system. Now, the public prosecutors, earlier, the police prosecutors, they used to be called PPs, police prosecutors in Bihar. I'm talking in Bihar where you are. In police prosecutors, they were part of the police organization. But when the 1973 Criminal Procedure Code was brought in, the prosecution wing of the investigation wing was taken away from the police and it was put under the district magistrate, and it was independent of the police hierarchy. So in 1973, the prosecution wing of the police went away and was part of the district magistrate. The district magistrate appoints, by a system of examination, the public prosecutors, the APPs, who are going in the courts of the chief judicial magistrate of the district, and for trials they go to trial courts of the judicial magistrate of third, second, and first degree. Then we have public prosecutors. I'm sure the same thing is going on till date because I've left Bihar a long time back. The public prosecutors in a district who is to appear on behalf of the state were appointed by the district magistrate in conjunction with the district judge. The district judge, from his observation in his courts, used to send a list of lawyers who were practicing in the district to the district magistrate with his recommendation, and the public prosecutors were chosen by the district magistrate to take charge of the cases which were in the district courts, district and sessions courts. Those were the warrant case, and those were the cases like murder, kidnapping for ransom, kidnapping. In the Indian Penal Code, it has already been given in which judicial court what sections of the penal code will be tried. It all depends on what is the punishment given to that offense. So you have the third judicial magistrate. These are small cases. These are not warrants cases. These are summons cases mostly. The summons cases, the difference between summons and warrants cases, I'm sure you must be knowing about it. The warrant case and the summons case. In the warrants case, the PP who has been given the case or chosen by the district magistrate for a term, he is the person who fights the case from the state. On the other side of they are defendants, the person who has been charged with an offense, after an investigation, the police puts a charge sheet. If it finds that it has got evidence to file a charge sheet, it files a charge sheet. But in most cases, what happens is charge sheet is filed, but in other cases, the police does not find any evidence and it makes a final report. That means it does not want to take the case further into a judicial court. However, it is the CGM or the judicial magistrates, they could take up those cases which have been finally reported by the police also into their consideration, and if they find that this is a relevant thing to be charge sheeted and tried, they can do that. This is their jurisdiction. Now the district and sessions judge, they are also part of, I wouldn't call it the senior judiciary, but they are part of the senior judiciary in the states. They are the persons from whom certain parts of the judiciary in the high courts are also gone. Now, mostly the crime and the investigation and its finality ends with the charge sheet and the beginning of the prosecution and its defense and its functioning in the courts comes to a conclusion that if this case can be convicted or this case does not have that much of, if this case does not have that evidence that it has to be, it does not need any further going ahead. But if the complainant is not satisfied, he can take that case to the High Court and later to the Supreme Court also for his grievance. The grievance mechanism has been laid down properly in these courts. So the second thing which I was talking about was this judicial thing. Both the High Court and the Supreme Court have appellate authority, and as far as the criminal procedure code is, criminal justice system is concerned, the complainant, if it is not satisfied, it can take his case to the High Court also and later to the Supreme Court also. As far as the judicial system is concerned, the third part is the judiciary. It goes hand in hand. Most of these things overlap. The prosecution is the people who are in the bar, who are in the prosecutors. Section 24 of the CRPC talks about who the prosecutors are. And as I have already told you, that the prosecutors are those who fight the criminal cases on behalf of the state and defend the defendants or the charged persons on the side as independent lawyers who have the license to practice in the bar or small courts or the district courts or even in the high courts and Supreme Courts. The third part is the judiciary. Now, how does the judiciary function? The judiciary, the lower judiciary as we call them, is the judiciary which is in our districts. Basically in our districts, where we have judicial magistrates of the third, second, and first degree, trial are held. The third thing is that we have district judge and session judge, I have already told you. They are the people who are appointed and they come into the service after going through an examination. The additional district judge and the district judge are now coming from an examination. The High Court judges, basically, as you know, that they are appointed by the state government and the Supreme Court. And so is the Supreme Court, how the High Court judges go to the Supreme Court. As far as the judiciary is concerned, the Constitution has made this judiciary absolutely independent. And it is on behalf of this judiciary that they take their concern, their view over the evidence produced in a court by the police and the prosecutors. If they find that the evidence is correct, if they find that the evidence is absolutely going hand in hand with the charges which has been taken, then they have a trial over a period of time and they come to a conclusion. They either convict or they allow the people to go out scot-free. Now, this is judiciary is the independence of the judiciary is basically a pillar of the Constitution. It gives the right of an individual. The article of the Constitution which gives him the right to life, liberty, and property that is given to him by the Constitution, and the judiciary has to keep in mind this right of an individual while giving justice. The third and the fourth part of this is after the justice has been done, we come to what is the correctional institutions. Before I go to the correctional institutions, I want to talk to you about a little bit how we differ from and how it has impacted our criminal justice system. In the UK and US, the prosecution wing, the prosecution wing is very much an adjunct, or the police is an adjunct to the prosecution wing. So when the crime has been committed and the police is collecting evidence for charge sheeting a crime, it is the job of the prosecution. In US, it is called the district attorney's office, which helps them in trying to get evidence. For instance, if the police comes in and brings in evidence of a murder against an individual, that these things are pointing a finger that this person is the murderer. Now, it is the job of the district attorney to sift through, go through the evidence which has been collected by the police and suggest to him that, look here, this evidence is not valid. This evidence is not admissible in the court of law. This evidence will not be bringing you a conviction, which your intention is. And that is why the district attorney's court and the police investigation go hand in hand, and it is a very good system. In 1973, this system was basically taken apart. The police prosecutors now became public prosecutors and assistant public prosecutors, and they were functioning independently of the police. And that is why the police today thinks that its job is finished once it has given the final report as a charge sheet or a final report to the court. Now, this is where we need some change in the criminal justice system, where a lot of people, a lot of jurists, a lot of police officers who have retired are asking the government to come with a police reform like this. You must have seen in very recent days some of the atrocities which have been committed by the police, say in Tuticorin in Tamil Nadu, where 2 people were killed in the police station, or the Hyderabad encounter case in which rape accused were caught and killed. Then the police in Vikas Dubey's recent case in Kanpur was killed, which is we call an extrajudicial killing, a killing which is not authorized by law to the police, but the police does it. So there has to be some accountability of the police to not only the state, but to the people whom it serves. This is a feeling which has come in the recent days, that the police should be accountable not only to the state according to the Police Act, but it should be accountable to the people at large, the people it serves. And in this direction, if you remember, during the emergency, it was felt that the police was used by the state in trying to arrest and do certain extrajudicial things which were not allowed by the law. And immediately after the emergency, when the government of Morarji Desai came into the center, they appointed a police commission for reforming the police. The police commission was headed by the then governor of West Bengal, an ICS officer, Dharamveer, and he had certain members of the jurists and police officers in their to support him to go into the reforms. And by 1982 and 83, 7 volumes of police reforms was submitted to the government, the then government. By then, the government had changed. The government of Mrs. Gandhi had come. Till date, the police reform has not been given any proper looking by the executives. When I mean executives, I mean the police executives who have to decide how the police has to behave and who the police has to be accountable to. The Dharamveer Commission report on the police reforms is gathering dust in the Ministry of Home Affairs. Now, later on in 2006, I think, in 2006, an ex-police officer, Prakash Singh, and Mr. N.K. Singh went to the Supreme Court and asked for certain reforms in the police which would make the police more accountable and to the public at large. So taking the accountability of the state as it is in the Police Act, which exists today also, to the accountability to the public whom they serve. But nothing has happened. The police reform is still, you might be seeing that a lot of people are writing on the need for a police reforms, as things are going from bad to worse. Coming back to the correctional, the fourth ghoda, the fourth horse of the chariot of the criminal justice system is the correctional. In our jurisprudence, criminal jurisprudence, we have said that a person is not a criminal even if he is charged. He is only a criminal when he is convicted. This is the criminal jurisprudence which we follow, which means if after conviction he goes to a jail or a correctional institution which is meant for the juveniles, for young kids, young people, for ladies, destitutes. Now these correctional avenues are they are the jails. So you have a subdivisional jail, you have a district jail, then you have a central jail. The central jail mostly houses people who have been convicted. But still in the central jail, you have people who are under trials. When I say what is under trial, that means those people who have been arrested, have not been bailed, and their cases are languishing in courts of the judicial magistrates or the district courts. Now, if you see the type of institution of cases which is in India, the NCRB, which has an accounting of these police these cases, they have said in 2018, just a minute, I'll give you a in 2018, the the cases which were instituted all over India were around 55 lakhs, not only under the IPC, but the special laws like the Excise Act, the Dowry Act, the special acts which have been created. Alka, the acts. So just see that in 1 year, 2018, we have around 55 lakhs FIRs all over the country, and 67%, and the conviction in the courts are only 7 to 8%. In certain cases, 3%. In certain areas, even in smaller courts, like the courts of the judicial magistrate, lot of cases are pending because either there are shortage of staff or the cases do not, the witnesses do not come or the complainant doesn't come. But in the CRPC, there are ways and means of trying to discard all these small cases. Like for instance, the 320 section of the CRPC, which is compounding. When I was the SP in Madhubani, I tried this with the help of the district magistrate and the district judge to compound all those cases in which the witnesses have not come for more than 3 hearings. And we made a huge list of those cases, submitted it to the district judge, and with the consent of the district judge, we gave it to the district magistrate for withdrawing all these cases with the consent of the complainant. Although there was a hue and cry with this action which was taken, but there are ways and means by which, if a person in the district or a district magistrate or a district judge, they come together and do certain action, then the cases in the judicial magistrate's cases can, and that is how even in the cases of the district and session judge, day-to-day hearing of cases which are important, that should be taken. Of course, from time to time, this exercise is being done by the district judge. And when the High Court judges come to the inspection of the district judges in the district, this is looked into, because pendency at all levels in the judiciary is a very big issue. And that is a very, very big thing for hampering our criminal justice system. Now, coming back to the correctional avenues, we have the jails, sub-jails, and the central jails. In the central jails, there are from time to time direction from the state to the jails that we must do certain things like skill development of people who are convicts, so that when they come in society, they are much more amenable to the society, acceptable by the society, and they can do and earn a living. The correctional avenues is also very stretched. The people who are in jails and who are under trial prisoners, let me tell you, the occupation of the jails, 67% of the occupation of jails of all kinds are of under trial prisoners. And what is the problem? They have to be taken to the court on the days of the trial. They have to be brought back. So there is a lot of involvement of revenue if these cases were quickly disposed by all under legal district, then we can have a criminal justice system for which we are striving to. The criminal justice system in our country is working fine, but it has to improve, it has to reform, it has to make amends. The guarantees which are given by the Constitution to this criminal justice system is provided by the articles of the fundamental right. in the end, I would like to bring your notice to some of the recent happenings which has been going around in the country. As students of law, I am sure you must be reading papers, and now all of you are on the internet. The Article 32 of the Indian Constitution is supposed to be a very important article. Article 32 of the Indian Constitution gives the right to the individual for remedies to any misgivings of the law, any law. When Ambedkar was making this law, people asked him, which is the most important section of the Indian Constitution, which you say? Then he said that Article 32, in which the remedy to constitutional remedies are given, is very important, by which a person can go straight to a High Court or a Supreme Court and seek remedy under this. Very recently, in a case of some persons who have been arrested in the Hathras case, the Hathras rape case in Uttar Pradesh, they went to the Supreme Court, and the justice, the Chief Justice of the Supreme Court, gave a judgment that the petitions or the writs under the Article 32 should not be brought to this higher court until unless it has been addressed in a lower court, that is the High Court. Now, a lot of hue and cry, a lot of people are writing on this, that the fundamental rights of a citizen is that it can go for a constitutional remedy to the highest court. And even Bhimrao Ambedkar, while writing the Constitution, had said that this is a very, very important article which gives our criminal justice system a leverage to go and seek justice at the highest level. So this is what I have to say about the criminal justice system. The criminal justice system is, as your director has said, is a legacy of the British period, and it needs change. The criminal justice system, the laws, the type of laws needs change. Of course, the laws in the Indian Penal Code, the CRPC, and even in the Evidence Act have been changed, have been amended from time to time by the states and the center. For example, the 366, the kidnapping sections have been changed. The 366A has been, but still we need, as the police reform of the Dharmveer Commission has said, that we need a reform in how the police is acting today and how it should act. It should not only be responsible to the state, but it should be responsible to the people whom it serves. That is most important. The accountability of the police as it is today is only to the state. It is responsible for all its actions to the state. But now it is very much needed. The police and the criminal justice system works for the people whom it serves. And lastly, I want to say that the criminal justice system does not just do justice to the poor people. The poor people are still denied the judicial avenues, although there are certain things which have been made, but the poor people cannot go to the higher courts. The poor people cannot even go to the district courts. And that is why we have to make this law, all the laws, the Indian Penal Code, the CRPC, much more congenial to the needs of the people who need them. Thank you very much. I am ready to answer any questions if the students are
Thank you, sir, for your Preeti lecture on the criminal justice system. Thank you, sir, very much. Now we will dedicate about 30 minutes for a question answer session by the students. Students may start asking now.
Good afternoon, sir. It's Rishabh, sir, LLB Part 2. I'm having, sir, one. Could I? Could I, sir?
Go ahead, go ahead.
Yes, sir. Sir, what is the role of police to dispense procedural justice?
Procedural,
Justice, sir.
what exactly do you mean by procedural justice?
सर जो प्रक्रियात्मक विधियां सर होती हैं
उसका एग्जाम्पल दो।
सर जैसे सर एफआईआर में और सर उसके बाद जो इन्वेस्टिगेशंस होते हैं उनमें जो समय लगता है सर उसके लिए।
हाँ, तो जैसा कि आपको मालूम है और जैसा कि सीआरपीसी में लिखा हुआ है अंकित है कि all the investigation has to be finished by the police in minimum time. For certain offenses, a time period has been given. And if the police does not finish its investigation, say for example, if a murder case accused has been arrested, and if the police does not file a charge sheet within 60 days, that murder accused has to be given a bail. So it is on the responsible of the police officers that they should put a charge sheet in minimum time. It should not delay. But what happens, Rishabh, is that the volume of FIR and other works which the police has to do, and in comparison to the police staff which has to do this job, is very much different. ये आप समझ गए ऋषभ?
Yes sir, thank you sir.
जो पुलिस स्टेशन में रहते हैं और जो पुलिस की कार्रवाई होती है उसमें बहुत डिफरेंस होता है, और इसीलिए हम लोगों ने समय समय पर पुलिस स्टेशन का स्ट्रेंथ बढ़ाने की कोशिश भी की है और बढ़ाई भी गई है। मेरे समय में 2 सब इंस्पेक्टर, 2 एएसआई और 8 कांस्टेबल पुलिस स्टेशन में रहते थे। हम 80-82 की बात कर रहे हैं। आज उसका 3 गुना फोर्स आजकल है, और इसीलिए पुलिस स्टेशन में जो भी केस होता है उसका जल्द से जल्द निपटारा हो, जल्द से जल्द इन्वेस्टिगेशन हो, जल्द से जल्द केस डायरी लिखा जाए। मैंने केस डायरी के बारे में नहीं कहा, लेकिन केस डायरी एक इन्वेस्टिगेशन का अटूट अंग है जिसको लिखना एक आईओ की जरूरत है, और वो चार्जशीट के साथ लगाकर वो जुडिशियल कोर्ट में देता है। एंड ऑन दैट बेसिस, तो ये जो आपने ऋषभ कहा, ये कम से कम समय में हमारा इन्वेस्टिगेशन पूरा होना चाहिए, लेकिन ये नहीं होता है, पेंडेंसी रह जाती है। पेंडेंसी पुलिस में भी है, जुडिशियल कोर्ट्स में भी है, हायर कोर्ट्स में, हायर जुडिशरी में। तो ये काम एक वर्क इन प्रोग्रेस है, चलता हुआ काम है। हम ज्यादा से ज्यादा कोशिश ये करते हैं कि जल्द से जल्द हम इन्वेस्टिगेशन का निपटारा कर सकें।
Yes, thank you sir.
अगर और किसी छात्र को क्वेश्चन पूछना है तो पूछें।
Sir, one more question sir.
हाँ ऋषभ बोलो।
Sir, Is criminal justice of India going to change, sir? As you told, and as we have seen for the last 2 or 3 years, which encounter incident took place by the police personals, as you told, sir, like Hyderabad incident 2019.
कुछ ऋषभ कुछ आप सोचते हैं कि as I told you
Yes.
that right from 1977 onwards, the first attempt of reforming the police and making it accountable to the public, to the people it serves, was made by the government of Morarji Desai when he appointed the National Police Commission. And the Police Commission gave its report by 1982-83, in which the studies were made of all the police functioning in different countries. And then they came to a conclusion that police has to be made responsible not only to the state, means when you say not only to the state, it doesn't mean the ruling government, but it is responsible to the people it serves. But today, I would say, I would not like to tell you, but I will say that the politicians of all hues, whether they are from any party, do not want the police to go out of their clutches. Whoever is in power wants the police to serve the ruling party in power. And that makes the police a little disturbed in its action. And that is how still it is work in progress. People really want the police to reform. It is archaic laws under which the police is functioning. That means laws which had been made by the Britishers. The Police Act is of 1861. The Indian Penal Code is of 1860. The CRPC came in 1882 first time, and then it was converted in 1970 when our law commission did something and came out with 1973 CRPC, which took the prosecution wing from the police, which made such a wrong move that today there is long pendency in the courts. There is even after charge sheet, if you see, if after charge sheet by the police, the charges to be framed in the court also takes so much of time. So until unless we cut down the time, we make it responsible, people responsible for either it is the police or the prosecutors or the judiciary, until they are made responsible, nothing is going to happen. And since you are studying law, and all of you are studying law, you'll be soon going into the second wing of the criminal justice system. Some people will be doing civic laws also, but you should take care that if you have to work, you must give some so it is you should look after the poor, the people who would be needing your services for their cases, whether it is in the civic side or the criminal side. I am telling this at the end of my speech because I feel very strongly that the poor people who want to get the judicial system, this criminal judicial system or any judicial system, the reaps of that judicial system, it is not made available to them. A poor person cannot go to the Supreme Court. A poor person cannot go to the district and session court. So when you people go as prosecutors, some people will become judges also. You will give examinations of the district judge and
Thank you, sir. Thank you for enlightening us.
Anybody want to ask?
Thank you, sir. Hello, sir. It's me, Vivek. So, what is the difference between a judge and a justice of court?
I guess Chaudhary sir has left the meeting. I guess there is some network issue occurring there. So
सर नेटवर्क इशू के कारण डिस्कनेक्ट हो गए हैं, कनेक्ट कर रहे हैं, वेट करिए।
We express our gratitude to Mr. Sushil Kumar Mishra, President of this college, for joining us online. To Dr. Ujjwala Mishra, whose inspiration led to this memorable session, we express our heartfelt gratitude. We thank the director of this college, Mr. Jayant Kumar, under whose guidance this event happened. We pay our heartfelt thanks to the principal of this college, Dr. K.K. Tiwari. Thanks to all the learned lecturers of this college, and a hearty thanks and good wishes to all the law students. Thank you all very much.
thank you, sir. On behalf of
Thank
all
you,
the
sir.
students.
Thank you, sir.
Thanks a lot, sir. I am also online. I am remaining online, sir. I express my heartiest thanks to all.
I would like to take this opportunity. Can you hear me?
Yes,
Yes,
sir.
sir, now
Yes.
you are.
I would like to take this opportunity to thank the management of the law college for giving me an opportunity to interact with the students of this law college, which is very old. And I would also like to remember today the personality who is behind this law college. This law college and its association with Sri L.P. Shahi was like a father figure to me. And I had very good association with him and talking to him on many aspects of progress in Bihar. He had a vision for Bihar, both in the industrial area and in the educational area. I used to talk to him as a young Industries Minister, he said to me when I was SP of Vaishali, which used to be his district, he said that it was in those days that we had thought of industrial states in all districts and giving ITI training to young people, which is today's skill development. So today I want to pay homage and I want to salute that leader of Bihar, Mr. L.B. Shahi, and of course the management of this institution for giving me this opportunity to interact with young people. And interacting with young people keeps you young. That's what I am trying to say. Thank you very much.
Thanks, sir.
Thank you, sir.
Thanks a lot, sir. And I hope you again give your precious